Welcome to PA Voter Information Network. This is Larry DeMarco, your host. If you didn't see part one of my interview with Richard Fine, where he was wrongfully incarcerated by a corrupt judge, go watch it now. You'll find it on my YouTube channel. So, what do you recommend? What do we do as ordinary citizens?
Okay, this is what happens. As ordinary citizens, we have to recognize that don't give up our power. We have power. The question is, where do we exercise it? The judges have power within a court system. Granted, they have the power, and they have the sheriff or someone else to enforce their power. So get out of that sandbox. Number one, don't go in the sandbox if you can avoid it. Number two, what can you do with respect to influence or control that sandbox? Here we have 39 states where judges are elected.
Like Pennsylvania, which is one.
Pennsylvania. So when you have a judge that is coming up for an election and there's something wrong with that judge, you knock him out. If it's a retention election, I don't know how Pennsylvania works, but in California, our courts of appeal and our California Supreme Court have retention elections every 12 years. The judge needs 50.1% of the people voting in order to stay in. So basically, what we can do as citizens is we can work to stop that 50.1% coming in.
We have retention elections as well, where it's a yes or no vote. I imagine, I don't know that percentage, but part of the reason why I've never taken the care to see what that percentage is because even the worst judge, the judges who get criticized by the media, get retained by 70, 80 some percent yes votes.
Okay. Well, what you can do is, as the Campaign for Judicial Integrity in 2014, what I did is I raised the no vote, which was in 2010 at 20.1% to 31.1% in 2014. Mm-hmm. And I did that using social media.
First of all, the advice that you gave, Richard, because I want to hold this point, you said that you think that people should really watch judicial elections and make sure they scrutinize and vote down or make sure a judge doesn't get elected before they get in, because almost once it's before they get in, it's a lot harder. Then the second thing you said is make sure you use social media and pay attention during retention elections. Now, you said the Center for Judicial Integrity. Is that your baby? Campaign
for Judicial Integrity.
Now, is that your website and your efforts, Richard?
Yes, the campaignforjudicialintegrity.org.
Tell us about it.
Okay, basically I started that, I think it was in 2012. And I started that because I was looking to go in and get active with respect to judicial elections. And it's, I don't seek donations or anything else on it. I'm really looking to have people act. And one of the things is with respect to legislators, people running for the legislature, to have legislators sign a pledge saying that they will fight judicial corruption, that they will enact legislation to fight judicial corruption. That's one thing that can be done. Another, and that means when someone's running for office, you make judicial corruption a point of the election. Like right now in the presidential elections, people are saying, well, we're going to reform the criminal justice system. Well, it's not the criminal justice system that's bad. It's the corruption in the judicial system, because we've just gone through to see what happens in the civil system and the domestic law system. So basically, it's the legislature that you have to hit, because the legislature gets elected, the assembly gets elected every 2 years, the state senators might get elected every 4 years. Your representatives, U.S. representatives, are elected every 2 years, and your U.S. senators are elected every 6 years. So you've got power.
Yeah.
You've got power to go in and make judicial corruption a point in every election. That's one thing. Second thing, as far as judges are concerned, you go in and you use social media to go in and expose these judges. Now, this is something that I've never really talked about before. How do you do it? There are a lot of people that are out there that are sending things out, but let's go back to the old chain letter.
Well, when you say how do you do it, Richard, I think it's important to comment that judges have the power to retaliate against litigants and against attorneys. And as you know, a common thing that happens is that attorneys get disbarred by judiciary committees and by friends of the judges who are also fear the same type of retaliation.
And that's why we look at it in the following way. With respect to the judges, if you're looking at a particular judge, number one, I'm not looking at attorneys to do anything, because attorneys are going to live with that fear and they're not going to do anything. But ordinary citizens can look at two things. One, who's contributing to the judge's campaign? And if the judges, who are you going to find contributors? It's going to be attorneys. So the first thing that you're looking at with the judge who's up for re-election is the citizen can go in to get the campaign contribution list. You see all the attorneys. You say, hey, this judge is getting a lot of money from attorneys who either are appearing before him or likely to appear in front of him. We don't want this judge sitting in there. And then you look at the Code of Judicial Ethics in every state, and there's probably going to be something like 4D1 that says that a judge shouldn't take money from someone who is appearing or likely to appear in front of them. I can guarantee you that's literally in every Code of Judicial Ethics.
Sure, and in California, Richard, you actually recommend California lawyers move for recusal almost all the time because they can't be impartial in front of all the county cases.
Yeah. But there's another thing in California, it's probably in a lot of other states, and that is in California it says if the judge gets $1,000 or $1,500, they have to recuse themselves from the party or the party's attorney. And if it's less than that, if an objective person thinks that there may be a problem, they have to recuse themselves. So consequently, start using those things and you say, wait, this judge is getting money from attorneys. He's going to be bound to recuse himself. Has he recused himself in cases where attorneys have been appearing in front of him?
So let's advise our viewers. Sure. Let's advise our viewers. Richard, the website I'm aware of is www.opensecrets.com, where you could actually put in a candidate or put in an opposing attorney donor and find out what type of bias. Do you know of any other quicker way or?
Well, that's one way. The other way is most states or most counties have the contribution list published online. And during any judicial election or anything else, during the course of the election, every 90 days, that's going to go online.
Yeah, not here.
Not here. Okay.
No, we don't do that here.
Well,
that I'm aware of.
Well, then it's going to have to take a little bit of digging.
We're doing, sure.
Go in, but if one person goes in and digs it out, then they can publish that.
So is that an ordinary practice? Are people doing that?
Well, one of the things that I do as a strategic consultant, the first thing that I do as a strategic consultant, and in California, where I'm not allowed to practice law, but I am allowed to be a strategic consultant where I'm not practicing law, but I'm digging up facts, is go in and find out who's contributed to the judge.
Sure.
And if it turns out that if the other side, if the attorney for the other side or the other side has made a contribution to this particular judge and this judge hasn't disclosed it, we nail them right then and there. So that's number one thing that you look at.
Before you go to number two, Richard, if I can just jump in some gray area cases, do you risk antagonizing the judge? Don't judges get, sometimes can't they take offense? How dare you suggest that I won't be impartial just because someone donated to my campaign? Do you ever run into that?
Absolutely. But see, the problem is that under the Code of Judicial Ethics, he's supposed to recuse himself. He's out. If he got $1,500 or more, if he received any type of contribution, he's going to be out. So you just knock him out straight on with a motion with a disqualification. He's automatically gone.
So second, I interrupted you, Richard. I'm sorry about that. What is the next?
Okay, so that's going to be number one. So you look to see if there's been any contribution by either the party or by the lawyer. The other thing that you're going to look at is you're going to look at if the person is pro se, or they now have a very nice name for it in California, self-represented litigant,
yeah.
SRL.
Okay.
Used to be called pro se, in pro per. Suddenly it's an SRL. So now
nice acronym.
What you now want to look at is to see if this judge has a history with respect to self-represented litigants. Now, this will get a little bit trickier because you now are going to be looking to see if the judge is doing something against a self-represented litigant that is not necessarily dealing as judicial decisions, but is coming from some type of an outside source or some type of a bias. And what I look at here is essentially is not the judge's decision, but is the judge refusing to address certain facts. Because that's different from his decision. Let's take a situation where you have a statute of limitations. Case is automatically gone. The judge refuses to recognize that.
So you see that happen. You see that happen in your practice.
I have a situation, right now where the case was brought after the statute of limitations has run.
By a lawyer against a pro se litigant, Richard?
Lawyer against a pro se litigant. The judge refused to recognize the statute of limitations. Didn't even deal with it. So now that's something extrinsic.
So that's an example of just one thing. So Richard, you're discussing really basically tracking judicial patterns, decision-making patterns, right? So you have access to a wide database of statistics to be able to do this. Is that right?
Well, I have access to what can happen in a particular case. Now we're looking at what can an individual do. Now, if we're looking at an election, for instance, and take one case. If you're dealing in an election, you only need one case. Because you can say, hey, Judge Jones, in this particular case, there was a statute of limitations. This judge didn't even recognize that. So It's not a question of his making a decision. So what do you have? Is the judge so incompetent that he's not recognizing something? Or is he prejudiced against the pro se litigant?
And Richard, if I could just bring to our viewers' attention just the most recent obvious example of this, the Stanford rape case with the defendant Brock Turner and the woman who said, know my name and wrote that book because she and the Stanford teacher got, who is the judge's name who got?
I forgot his name.
I forgot, but I'll put it at in post-production, I'll put it on the caption. But what that was a movement to recall that judge, having a second election, and he lost because there was enough outrage with the assistance of the Me Too movement and social media, as you mentioned, right, Richard?
Exactly. Exactly. But now we're dealing, let's take any judge and someone finds this type of a case and they put it out there on social media. Now, how are they going to do this? And this is something where the average citizen doesn't have enough money to go out and go into a major campaign. But what they can do is they can use what's called the chain letter, where they send this information to 10 of their friends, if they have 10 friends. And they tell those 10 friends, send this out to 10 of your friends, and do the same thing. And this will blossom.
Sure, you're talking about emails, but Richard, we also can just do posts in social media groups, judicial accountability groups, anti-corruption groups, because there's so many now, state to state, countrywide Facebook groups that are watching judges.
Exactly. Yeah. And so you do that. And with doing something like that, and let's take in Pennsylvania, you'll have a judge and you just start this out with the groups in Pennsylvania, or you can spread it around anywhere else saying, this is such and such judge. This is what he's done. This is the case. Do not reelect this judge, or say we suggest that this judge not be reelected. Spread the word, and see, and you'll end up, if you start early enough, to get it blossom. Now, the change that I did on the California Supreme Court, I did that in 2 weeks before the election. In a 2-week period of time, I raised 10 points on the no vote. So if you start early enough, you can really get it going. These are the things that we can do. Now, you have some people who are out there saying, well, you should try and attract reporters and so forth to do things. But how are you going to attract a reporter to do something if you're just going in there and saying, well, I've got a story, and you just say it's a vague story or something else? You have to go out there and do things. We have to be the activists. And this is easier than getting 100,000 people to march.
Social media. So, Richard, is there enough protection for whistleblowers? You're a whistleblower, and you're talking about everyone basically standing together. But the one person who makes the most noise, does our laws protect whistleblowers enough?
No, because first of all, in a sense, I don't know, technically, I am not a whistleblower, because the whistleblower law is made to protect the individual that works for the government or works for a government contractor that is exposing the fraud.
Like Edward Snowden and the current whistleblower in the news relating to the Trump-Ukraine issue.
Exactly. I mean, so both of them, Snowden was working for a government contractor. And the current guy was actually working for the government. Now, people like myself, in a sense, are not a technical whistleblower. I am someone that is independent, that was following the law. This isn't even a judicial decision, because he didn't go in and say, okay, we have a statute of limitations, and I'm saying the statute hasn't run. He didn't make a judicial decision. He didn't even address it.
So, Richard, would you recommend a new law passed where someone in your situation who stands up and speaks out but then gets disbarred, do we need a protection for that fact scenario?
Oh, absolutely. Because what happens is this. Someone in my situation who is, shall we say, fraudulently disbarred and lost a tremendous amount of money by the judges illegally taking away all the money that I earned on class action cases from 1996 onwards, which was a lot of money.
You're talking millions, aren't you, Richard?
Yes, I am. Yeah. And basically, if I go in to court and try and sue for that money, I'm not going to win because the judges are still retaliating against me. To this day,
So how can you handle cases if you don't have a license to practice in these jurisdictions?
I don't handle cases in those jurisdictions. In strategic consulting, I tell people I'm not qualified to practice law in these places. In the U.S. Supreme Court, I'm qualified to practice law. I can practice there because I called the Supreme Court and I asked whether I'm still good in the Supreme Court. They said yes. I explained to them what happened. They said, didn't bother us. You know? And so that takes place. I had one person that called me, and he had a unique situation. He said, Richard, he said, I have attorneys in Washington, D.C., I have attorneys in New York, I have attorneys in California. My California attorneys are writing a brief, but nobody understands my business. He said, I need someone who can take everything and explain the business in 2 paragraphs over a weekend. He said, I'll send you, I said, my personal attorney will be available to you. I'll send you thousands of pages of documents over the weekend. I need you to distill this because none of these people can do it because all these attorneys are experts. And as experts, they all have tunnel vision. No one has the ability to absorb and explain this in very, very simple terms. That's what I do.
And you do. So do you think, Rich, I just want to ask you one other question, and then again, I actually would love to have you back. But Richard, do you think the Judicial Code of Ethics is strong enough and the enforcement is strong enough?
The Judicial Code of Ethics, the California Code of Ethics, which basically mirrors the ABA Code of Ethics, is strong. I mean, the enforcement is literally non-existent.
So let's talk about that a minute. Richard, do you think that the conflict of interest rules are strict enough or are specific enough? Because it seems like judges can say, you know what, this would not, even though there's the appearance, they can still say it's broad enough that, well, not for me, I'm special, I'm not going to be influenced.
Well, the solution is to take you right to the bottom line. Judges should not be in a position of judging conflicts of interest. That's where the problem exists. Basically, what you have, let's start with the federal system. In the federal system, the United States Supreme Court judges itself as to whether they have a conflict. That
They all do. They all do.
Well, we take it down next to the circuits. The circuit judges do the same thing. At the district court level, it becomes a little bit different. Like in the Central District of California, they hand it over to another judge sitting in the same district court to judge their colleague.
Slightly better. Slightly better, right?
Yeah. It's not even any better because they're judging every day.
Right.
Basically, there should be an independent administrative body that should be judging all the conflict of interest. As soon as a motion for a conflict of interest is made, it should be taken out of the judiciary and put into a separate body.
And the judicial enforcement, disciplinary bodies, usually is within the same branch of government. Do we need to have enforcement in a different branch of government?
Absolutely. Now, and here I'll use California again. In California, we have the Commission on Judicial Performance. And what happened with that is we just had an audit, and they found that over the last 10 years, that commission did literally nothing. So basically what you need is that, and that commission is made up, the commission itself is made up primarily of judges and maybe a couple of citizens and so forth. You got to take judges off of that commission.
Completely off.
Completely off. That means changing the California Constitution. But you have to remove judges from any situation where a judge is judging another judge. Because as long as judges are judging judges, judges are going to cover for judges. Now, with respect to that commission, then we have another issue as to who is going to be on that commission. A lot of times you have, say they're appointed by the legislature or something else on this order. Once again, you're into a political situation as to appointing these people. You're going to have cronyism. So we have to find a way to have the people on that commission be either elected with criteria that they can't be judges and maybe can't even be lawyers.
Sure.
And
because lawyers are subject to the authority of the judges that they would be ruling.
Exactly.
That they would be judging.
So we bar lawyers, we bar judges. We look for more ordinary citizens and maybe have elections of citizens. That may or may not be the best way, I don't know. But we have to set up those barriers. And then the other part of it is that we do not allow private contributions in those elections.
Which
elections are state or federally funded so that no one can influence those people through contributions.
But right now we have a judicial ruling that donations are free speech, so we have a problem there too.
Well, not if we legislate it.
That's right.
See, if we do it by legislation, then no donations.
Which is what you recommend.
I would, yes, I definitely recommend that, because I think as long as you have private donations going in, you're going to have influence. If I may extend this into another level, arbitration. Well, everything now has arbitration, and the judicial system says arbitration is good. But if you look at arbitration, take a look at, they call JAMS, Judicial Arbitration Mediation System, or whatever it's called. JAMS's rules, it's very, very interesting. The JAMS present rules, the speedier rules, says that JAMS will give you 5 people to select from. JAMS is choosing the people. You don't have a choice.
Right.
So basically, already you've got a real problem that is sitting there. Unless you and your other party agree on a particular JAMS judge or JAMS arbitrator, you're screwed. Who is JAMS choosing? JAMS is choosing people that one of the parties or the other parties may have used a number of times.
Of course.
Look at the American Arbitration Association. Now,
sure.
Look at these rules, and you're going to find that you have the same problems with the arbitration groups as you have
with the court system. Sure. Richard, we've really covered a lot this afternoon. We're going to have to leave it there, but I would love to have you on again so we can get to some more issues that we didn't even cover today.
It'd be my pleasure.
Well, Richard, thank you for being a guest on PA Voter Information Network. I appreciate you appearing.
Okay, thank you, Larry. I look forward to coming back again.
I look forward to communicating with you again, sir, as well. Take care now.
PA Voter Information Network. It's a game changer.